Objection, hearsay. Now you hear that all the time, but, and there's always a but, hearsay has exceptions. Today's case is about one of those exceptions called the excited utterance. In Mayberry, a group of friends are ambushed by a gunman. One of the victims, Triplet, he's shot in the foot. Triplet flees with the group to a house several blocks away. Gunman disappears. Triplet says the shooter was Lil Wayne. Now, Triplet isn't at Lil Wayne, aka Mayberry's trial, so one of the other friends testifies to his statement. Defense counsel objects, argues too much time had passed for the excited utterance rule to apply because he didn't say it at the moment he was shot, but later when he was hiding in the home. However, the trial and appellate court disagree. First, excited utterances are kind of statements relating to a startling event or condition made while the declarant was under the stress of excitement caused by the event or condition. Now, there's a three-part test for this, as noted in the Sutton case, and the question is, if the event has concluded, can the excited utterance rule still apply? Well, the appellate court holds that excited utterances are not limited to statements made during an ongoing emergency. Rather, the critical inquiry is whether the statement was made while the excitement of the event predominated. Now, remember when Triplet indicated who the shooter was, he had just been shot in the foot, so he was still in a lot of pain even though the shooter was long gone. And that pain meant the event still predominated. So the judge made the right call in letting the statement in. Anyways, that's all I have. Thanks for watching. I should probably add something here for criminal law because in criminal cases we have what's called the Crawford rule. And in essence, Crawford states that if the statement is admissible as an excited utterance, it can still be barred if it's testimonial. Now, testimonial in this case means whether the statement is being used as a substitute for trial testimony. The Sutton case lays out a two-part test to determine whether the statement is testimonial. One, is it made in a solemn fashion? And two, is it intended to establish a particular fact? So let's break this down. A solemn fashion statement is formal, such as under oath or made to a police officer or said in a situation where there is some threat of consequence for dishonesty. And a statement to establish a particular fact, well, that's when the person is making the statement, let's say Triplet here in today's case, and he's given information about something that happened that could be used for criminal prosecution. Generally, if the statement meets both criteria, even if it's an excited utterance, it's probably not coming into the criminal case. But it is still fair game for civil litigation. Now, applied here, Triplet is making the statement to his friend, not a cop or an investigator, and given the severity of his wounds, a reasonable person in his position probably would not have anticipated that what they're saying to their friend while waiting for medical personnel to arrive would later be used in some sort of prosecution. So the statement doesn't trigger Crawford. Anyways, that's all I really have. Thanks for watching.